The Judiciary Committee will please come to order, a quorum being present. Without objection, the Chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the Chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. Pursuant to notice, I now call up H.R. 4, the Voting Rights Advancement Act of 2019, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 4, to amend the Voting Rights Act of 1965 to revise the criteria for determining which states and political subdivisions are subject to Section 4 of the Act and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 4, the Voting Rights Advancement Act of 2019, is a comprehensive and much-needed proposal to amend the Voting Rights Act of 1965 in a number of ways to restore that core civil rights statute to its full vitality. The bill is a response to the Supreme Court's disastrous 2013 decision in Shelby County versus Holder, which effectively gutted the Act's most important enforcement mechanism, its pre-clearance requirement contained in Section 5, by striking down the coverage formula that determined which jurisdictions would be subject to pre-clearance. The Court mistakenly, in my view, considered Section 5 an unjustified intrusion into state sovereignty. The majority, however, expressly said that Congress could, quote, draft another formula based on current conditions, close quote, and that, among other things, is exactly what H.R. 4 does. Specifically, H.R. 4's coverage formula provides that looking back 25 years, states in which 15 or more voting rights violations have occurred, or those in which 10 or more violations have occurred if at least one of the violations was committed by the state itself, would be subject to pre-clearance. Localities that have committed 3 or more violations within that 25-year look-back period would also be subject to pre-clearance. H.R. 4 also strengthens other related provisions of the Voting Rights Act. The bill expands the availability of bail-in coverage so that a court can impose pre-clearance on a particular jurisdiction that has violated the 14th or 15th Amendments, the Voting Rights Act, or any other federal anti-voting discrimination law. It adds a practice-based pre-clearance formula that would subject any jurisdiction that engages in certain practices that have historically been used to discriminate against minority voters, like changing methods of election or jurisdictional boundaries or imposing voter identification requirements, and in most instances meet certain demographic thresholds. It expands the Attorney General's authority to send federal election observers. It requires states and localities to provide critical public notice and enhance transparency of voting changes and practices when they are implemented, and it amends the Act's injunctive relief provision to allow private parties to seek such relief and to make it easier for them to obtain preliminary injunctions. Through a series of hearings before the Subcommittee on the Constitution, Through a series of hearings before the Subcommittee on the Constitution, Civil Rights, and Civil Liberties, we have established a substantial record documenting an ongoing and disturbing pattern of voting discrimination by jurisdictions around the country since the Shelby County decision. This record justifies the continuing need for pre-clearance and bolsters Congress' authority for enacting H.R. 4. The record demonstrates that states and localities, and in particular those that were formerly subject to the pre-clearance requirement, have enacted or engaged in various voter suppression tactics, such as imposing burdensome proof of citizenship laws, polling place closures, purges of voter rolls, significant scalebacks to early voting periods, restrictions on absentee ballots, and laws that make it difficult to restore the voting rights of formerly incarcerated individuals. These kinds of voting restrictions have a disproportionate and negative impact on racial and language minority voters. While there are too many egregious examples to recount here, we heard one illustrative example from the testimony of Stacey Abrams, the founder and CEO of Fair Fight Action and a 2018 Georgia gubernatorial candidate. In the November 2018 election in Georgia, under that state's exact match law, 53,000 registered voters, 70% of whom were African American, were placed in pending status and at risk of not being counted by the Secretary of State, who was also personally the Republican nominee for governor that year because of minor misspellings on their registration forms. A federal court ultimately put a stop to this practice because of the, quote, differential treatment inflicted on a group of individuals who are predominantly minorities, close quote, but it acted just 4 days before the election and only after a prolonged period of confusion. In other words, the damage had already largely been done by the time the court could act. As we consider this record and the need for H.R. 4, It is well worth remembering why it was that Congress put a preclearance requirement in the Voting Rights Act in the first place. Before the act, many states and localities implemented voter suppression measures aimed at African Americans and other people of color, secure in the knowledge that it could take many years before these measures could be successfully challenged in court, if at all. As soon as a court, after years of litigation, overturned one law, the offending jurisdiction would enact another law to replace it. This meant that black voters could be shut out of the polling place even if they succeeded in every lawsuit against a discriminatory voting law or practice, because a new one would already be in place to keep them from the ballot box. In response to this discriminatory game of whack-a-mole, Congress required certain jurisdictions with a history of racial discrimination in voting to get approval from the Justice Department or from a federal court before making any changes to their voting laws or practices. Congress intended this preclearance requirement to address what the Supreme Court called a, quote, unremitting and ingenious defiance of the Constitution, close quote, by states determined to suppress minority votes. The success of the Voting Rights Act with its effective preclearance requirement was apparent almost immediately after the law went into effect. For example, registration of African American voters and the number of African Americans holding elected office both rose dramatically throughout the Deep South after the VRA's enactment. Yet decades later, problems remained. As the Constitution Subcommittee, of which I was the ranking member at the time, and Mr. Shabbat was the chairman at the time, heard from dozens of witnesses and assembled thousands of pages of evidence of ongoing discrimination when it last reauthorized the Act in 2006. Notwithstanding this exhaustive record compiled by Congress, the court in Shelby County essentially decided to substitute its own judgment for that of Congress. Not surprisingly, the Shelby County decision unleashed a deluge of voter suppression laws across the nation, including in many states and other jurisdictions that had been subject to preclearance before Shelby County. For instance, within 24 hours, Texas and North Carolina moved to reinstitute draconian voter ID laws. While courts later held both of these laws to be intentionally racially discriminatory, during the years between their enactment and the court's final decisions, these states held many elections while the discriminatory laws remained in place. Another particularly troubling aspect of the court's reasoning in Shelby County was its emphasis on the supposed equal sovereignty of the states and on states' authorities to administer elections, even when they have abused that authority by denying the right to vote. The court's reasoning barely acknowledged that the constitutional amendments enacted after the Civil War during Reconstruction, namely the 13th, 14th, and 15th Amendments, were intended fundamentally to reorder Congress's relationship to the states and to give Congress the power to supersede state sovereignty when needed to enforce the mandates of those amendments. Indeed, the Supreme Court has held that Congress' authority to enforce the 15th Amendment's prohibition against racial discrimination by states in voting means that Congress, quote, may use any rational means, unquote, to make laws against racial discrimination in voting. Notwithstanding the Shelby County decision, the court has thus far left this highly deferential rationality test in place. In short, Congress has the power and indeed the obligation to reverse this tide of voter suppression laws. The 14th and 15th Amendments expressly empower us to enact laws protecting the right to vote and guaranteeing the protection of all citizens. And although the Supreme Court's decision in Shelby County did great damage, the court made clear that it was not striking down preclearance altogether. We can no longer afford to wait. The right to vote lies at the very core of our democracy and is foundational to the rule of law. Support for reauthorizing the Voting Rights Act, including its preclearance provision, has historically been bipartisan. There's no reason why it should not once again enjoy bipartisan support. I urge the committee to report H.R. 4 favorably to the full House. The ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, will have his opening statement placed in the record. I now recognize the ranking member of the Constitution Subcommittee, the gentleman from Louisiana, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. As I have said at previous hearings on this bill, every single one of us, every member of Congress, everyone on this committee agrees that discriminatory treatment in voting based on race or sex is abhorrent. It's prohibited by the Constitution, as it should be. It's prohibited by federal statute, as it should be. But too often, complaints of discrimination in voting have nothing to do with discriminatory treatment. Instead, rules entirely neutral on their face are sometimes claimed to be discriminatory simply because they have a disparate impact on one group or another. But here's the key point. Disparate impacts are not proof of discrimination. Indeed, they are statistically inevitable. Yet the bill we'll be discussing today, H.R. 4, would prevent states from enforcing their neutral voting rights laws if they aren't approved by the Justice Department. The problem we have with that is that the Justice Department is an entity with a history of politicizing that power in the past. And it would do so based on claims of disparate impact, which are statistically inevitable, again, and not evidence of any racially discriminatory treatment. The disparate impact approach to civil rights and the assumption that different outcomes are the result of discrimination is fundamentally unsound, for the same reason that social scientists are trained that correlation does not imply causation. In other words, there can be all sorts of correlations between one event and another, but that doesn't answer the question as to why that correlation exists. Moving a polling location from point A to point B, for example, may well mean that one demographic group or another will have to travel one more block to get there than another demographic group. But that doesn't mean moving the polling location one block this way or that is discriminatory. Regarding discriminatory treatment in voting that's based on race, Section 3 of the Voting Rights Act, which is permanent federal statutory law, of course, remains in place, and it's in full effect. And it allows any federal judge, upon proof of discriminatory treatment in voting based on race, to subject the offending jurisdiction to whatever preclearance regime the court deems appropriate. But H.R. 4 would go far beyond what is constitutionally permissible, and it would allow a politicized Justice Department to veto or amend state voting laws to the political advantage of the party in power. As witnesses at the hearings on this bill have explained, Congress cannot constitutionally enact legislation denying states and localities control over their voting rules when there's no evidence they've been engaging in discriminatory treatment in voting based on race. The Supreme Court's holding in City of Bernie v. Flores held that a law enacted pursuant to the 14th Amendment must be congruent and proportional to actual constitutional violations that can be established in an evidentiary record. In considering whether a law satisfies Bernie's congruence and proportionality standard, the court assesses whether a record of actual constitutional violations exists, that is, intentional discrimination in voting based on race. The Supreme Court has taken a dim view of statutes aimed primarily at eliminating disparate impacts that don't themselves violate the 14th Amendment. But that's what H.R. 4 does. Compounding that constitutional error, H.R. 4 also requires certain types of voting laws to be subject to preclearance automatically, such as legal voter verification laws, not only without any prior showing of discrimination of any kind, but simply by federal fiat. This committee and other organizations have claimed to have compiled evidence to demonstrate the need to amend the Voting Rights Act. But the list of examples overwhelmingly includes Department of Justice objections to state and local voting rules changes under Section 5 of the old Voting Rights Act, Section 2 cases, and cases in which a jurisdiction may have stopped defending the case after the district court level. Department of Justice Section 5 objections are just that. They're not any official determination by a court of ultimate jurisdiction that a state or locality actually engaged in disparate treatment voting based on race. Section 2 cases can continue to be brought today, just as other civil rights cases are brought, so such cases don't demonstrate the need to amend the Voting Rights Act. In cases in which a jurisdiction may have stopped defending the case or settled the case after the district court level may simply be an indication that the jurisdiction couldn't afford to continue appealing the case up to a higher court, where the jurisdiction may ultimately have won if they had been afforded the opportunity to. Proponents of H.R. 4 argue that victims of voting discrimination should not have to spend their time and money to go to court first to have their claims decided. However, both Section 3's preclearance provisions and H.R. 4's preclearance provisions require litigation prior to preclearance processes going into effect. Indeed, Section 3 preclearance requirements can be obtained after litigating just a single case. And litigation under Section 2 of the Voting Rights Act, which also remains firmly in the federal code, can result in preliminary injunctions that stop challenged voting rule changes before they go into effect. This is a lot to say, but at the end of the day, we would do one thing. We urge all of our colleagues to join us in opposing this bill, which would unconstitutionally deny states and localities control over their own voting rules when there's absolutely no evidence at all that they've been engaging in discriminatory treatment in voting based on race. With that, I yield back.
The gentleman yields back. I now recognize the chairman of the Subcommittee on the Constitution, Civil Rights, and Civil Liberties, the gentleman from Tennessee, Mr. Cohen, for his opening statement.
Thank you, Mr. Chairman. As chairman of the subcommittee, which has a distinguished list of former chairman and ranking members, I'm proud to be that member, and we have a great committee. We've had extensive hearings, as has the committee, and outstanding witnesses. And it's been clear, including testimony from a professor from Caltech who studied the statistics of all of this, that we need a preclearance formula, that it helps people vote, that the voting impediments were in the states, mostly, which were struck down by the Supreme Court, the old Dixie states, that had an opportunity to come forward, but instead, old times there were not forgotten, and they continue to find ways to disenfranchise people. So we have done our job. The H.R. 4, the Voting Rights Advancement Act of 2019, would once again give effect to the preclearance requirement of Section 5 of the Voting Rights Act, gutted by Shelby County versus Holder, as the chairman has mentioned. That struck down that coverage formula that was necessary. As a result, preclearance provision remains dormant until we adopt a new one, and we hope to do this session. I want to commend Mr. Sensenbrenner, who was a chairman at the time, who helped pass the Voting Rights Act in the early part of this century and was one of the supporters of a renewal in a previous Congress. He's been a stalwart on this, and I thank him for his work. H.R. 4 was introduced by Terry Sewell of Alabama, an outstanding congressperson, and her district includes the Pettus Bridge, where John Lewis marched and was beaten by Alabama state troopers to get people in Alabama the right to vote. People have been brutally beaten, some have been killed, to stop people from getting the right to vote. That's sad in America. It's happened in Alabama, it's happened in Mississippi, it's happened mostly in southern states, which is unfortunate that it happens anywhere. But we need this new coverage formula that would be one that would say if you had 15 or more voting rights violations that occurred in that jurisdiction over the previous 25 years, or where 10 or more violations occurred, if at least one of those violations was committed by the state itself, then you'd have a area that would be covered by preclearance. If the political subdivision would be covered also if it had 3 or more violations in the previous 25 years. Jurisdiction could be covered for a maximum of 25 years. Some have said, for a maximum of 10 years, excuse me. Some have said that you shouldn't have these standards and have to go to court to get your laws enforced and have preclearance. That is wrong. But we do have in our country, and as we should, laws about people who commit wife abuse, and they have certain restrictions put on them before they can take certain actions. They have injunctions to protect the public and protect the individual who's a victim of the abuse, sexual assault. It doesn't have to be wife abuse, it's sexual assault. And we have it in other areas. And with these states have had certain number of violations in the previous years, they are basically just like an abuser, a sexual abuser. And if you have knowledge that they are, you're foolish not to put some restrictions on them to protect the person that's been abused. In this situation, we're protecting the people who live in the jurisdictions that have been abused in the past because they've shown their colors. And as Maya Angelou told us, when they show you what they are, believe them, because you see what they are. And that's what this is about, preclearance. When people have shown you, political jurisdictions, what they're about and what they think and how they act, you must put up some preclearance requirements. Otherwise, it makes no difference because they can do their, as was said in Blazing Saddles, that their voodoo that they do so well, they can do that and they get away with it because you can't stop it before the election's been held and you've stopped people from voting. So this strengthens the Voting Rights Act in other ways as well, includes enhancing the Act's bail-in preclearance provision, adding a new practice-based coverage formula, and revising the preliminary injunction standard for enforcement actions under the Act, so plaintiffs can more easily halt potentially discriminatory voting practices while they're being challenged in court. The right to vote is the most fundamental right in our democracy. It's the key, it's for which we rest upon, the fulcrum. Unfortunately, the right of African Americans and other members of racial and language minorities to vote has been threatened and undermined throughout our nation's history. It's a sad part of our nation's history, but it's always been there. Count the number of peas in a jar. Multiply 16 times 14,667. And if you can't pass those tests, you don't vote in Alabama. That was the law before some of these, the 50s and 60s and before. They gave the African Americans the test. They didn't give the Caucasians the test. They got a waiver. Voting Rights Act with an effective preclearance provision went a long way towards righting those wrongs we've seen in our nation's history, but sadly, since the effective neutering of preclearance provisions, voting rights for minorities once again under assault in many parts of our country. We gathered evidence in our subcommittee. We had 7 hearings before the subcommittee. We had 1 hearing before the full committee and multiple hearings in other committees. That evidence provides an extensive and detailed record of continued and ongoing voter suppression efforts, particularly by those jurisdictions that were once subject to preclearance in the effective absence of preclearance since the Shelby County decision. North Carolina jumped into action with a sweeping voter suppression law that a federal appeals court, right after Shelby County versus Holder, they passed the law and a federal appeals court held it unconstitutional, finding that it intentionally, quote, targeted African Americans with almost surgical precision. We also heard about recent measures to make it difficult or possible for minority voters to exercise their right to vote. Those measures include polling place closures and relocations, the purging of voter rolls that disproportionately target racial and ethnic minority voters, discriminatory photo ID laws, and restrictions on ex-felon voting laws, all of which are designed to make it harder for African Americans and other racial and ethnic minorities to vote. I would submit that disparate impact is important, and it shows the intent of the parties. And it's been shown to be the intent of the parties in many parts of the country, but particularly in the Deep South. Last month in Memphis, we learned about Tennessee's third-party registration law that would impose draconian penalties on groups like the League of Women Voters, who work to register new voters because of minor errors and omissions in registration forms. They would face criminal penalties, a way to try to get them not to engage in voter registration and restrict their activities. Federal court temporarily blocked this, finding that it was troublingly vague. Back in May, we learned about a similar law in Texas, about many other examples of voter discrimination in Texas, which has proved to be particularly troublesome recidivists when it comes to voter discrimination. They jumped into action just like North Carolina and passed a law as soon as Shelby County versus Holder came down. So we've seen states engage in racial gerrymandering designed to dilute the strength of minority voters. We've seen that in many areas, particularly North Carolina and others. The Voting Rights Act preclearance provision required certain jurisdictions with a history of voting discrimination against racial and language minorities, again, those predominantly in the Deep South, to obtain approval of any changes to voting laws and procedures from the Department of Justice, the U.S. District Court for the District of Columbia before such changes take effect. My friend, the ranking member, says that the Justice Department can't be so trusted. They get involved in these things. Well, I don't think you have to worry about that with this Justice Department. But if you get another Justice Department, you have to worry about it. To quote my friend Mick Mulvaney, get over it. Things happen. This mechanism ensured that new voting rules and practices in jurisdictions with a history of discrimination were fair to all voters. It rightly prevented potentially discriminatory voting practices from taking effect before they could harm minority voters. And in this way, preclearance proved to be a significant means of protection for the rights of minority voters. Congress has repeatedly reauthorized preclearance provision on an overwhelmingly bipartisan basis. Most recently in 2006, Sensenbrenner was chairman of this committee, and the House passed it 390 to 33, and the Senate 98 to nothing. A result due in no small part to the substantial efforts of Mr. Sensenbrenner and then subcommittee ranking member Nadler. In the absence of an effective preclearance regime, it is unsurprising that discriminatory measures have and will continue to undermine the voting rights of racial and language minority voters and erode our democracy. While Section 2 of the VRA, which prohibits discrimination voting, remains in effect, it is much less effective, significantly more cumbersome, and often prohibitively expensive to enforce the act. Most importantly, plaintiffs cannot invoke Section 2 until after an alleged harm has taken place, after the horse has left the barn. Election's taken place. People have been stopped from voting because of these laws. And so you can say later, oh, it was illegal, but the election's over and the folks are in who wouldn't have otherwise been in. Requiring discrimination victims to rely solely on such a remedy, Section 2 neuters the act. The onus, therefore, is on Congress to create a new coverage formula to restore the Act's most important enforcement mechanism. It's a preclearance requirement to find other ways to strengthen the Act. H.R. 4 goes a long way toward meeting this obligation. So, in the spirit of all the civil rights workers who worked hard to get people the right to vote, particularly with honor to John Lewis, who was beaten in Selma, Alabama, and others who were beaten, and people who were shot, like Miss Liozzo from Detroit down in Alabama, and Schwerner, Cheney, and Goodman, who were killed in Mississippi, in Philadelphia, Mississippi, when they went down there to register people to vote, Freedom Summer. In respect of their sacrifices and fairness and justice, we need to pass H.R. 4 and urge the committee to report it favorably to the full House. There's no problem with disparate impact. There are problems today in getting people to vote. They are clear on the face of history and the current course of events and legislation in our nation, particularly in the Deep South. With that, I yield back the balance of my time.
Gentleman yields back. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 4, offered by Mr. Nadler. Strike all after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment in the nature of a substitute makes 3 technical changes to H.R. 4 as introduced, but makes no major substantive changes. First, it amends the provision defining applicable date of coverage so that the end date is the end of the year of enactment of H.R. 4, which we hope is December 31st, 2019. The bill currently says December 31st, 2015. Second, the amendment adds, quote, to a voting qualification standard practice or procedure after the phrase, any change made by a state or political subdivision on page 27 of the introduced bill to be consistent with how the term change is limited in the rest of the bill. Finally, the amendment adds a clarifying definition of the term prevailing party as used in the Voting Rights Act's attorney's fee provision. A prevailing party is defined as one that, quote, receives at least some benefits sought by a civil action under the VRA, states a colorable claim, and can establish that the action was a significant cause of a change to the status quo, close quote. The bill's other provisions remain untouched, and I encourage adoption of this amendment in the nature of a substitute. I will now recognize Mr. Johnson for any comments he may have on the amendment.
Mr.
Gentleman
Chairman.
has no comments.
Mr. Chairman.
Gentleman from, for what purpose does he, gentleman from
We'll strike the last word.
Gentleman is recognized.
Mr. Chairman, I think that my record in support of extending the Voting Rights Act and strengthening the Voting Rights Act speaks for itself. We've heard numerous comments by my colleagues from the other side of the aisle about those efforts, most recently in 2006. Unfortunately, moving H.R. 4 today is going to set back efforts to fix the mistake that the Supreme Court made in the Shelby County case. Every civil rights bill since the 1950s that have passed and been signed into law has been done on a bipartisan basis. This bill is not. Now, following the Shelby County case, I was involved in a number of negotiations with people on the other side of the aisle to figure out what we could do to come up with a compromise bill that would attract bipartisan support. We were able to achieve that, but there were those that are opposed to the entire philosophy of the Voting Rights Act, specifically preclearance, that ended up obstructing bringing that out. During those negotiations, people on both sides, Republicans and Democrats, gave things up to try to reach something that would get bipartisan support. We were successful in doing that. What has happened in this bill is all of the things that the Democrats gave up gets back in the bill. It's kind of like the phoenix rising from the ashes. But none of the things that the Republicans gave up end up going back into this bill. So again, it is undoing the bipartisan negotiations that occurred in 2014, 2015, and 2016. As a result, this bill will pass the House. It won't go anywhere in the Senate, and it is another partisan move that has made something that has been previously bipartisan in nature partisan. It is a poison pill. It will be viewed that way, and it will never become law. So I'm not going to vote for this bill, despite my record in support of voting rights protections. I do believe that all of the civil rights laws that were passed in the 50s and 60s, the Voting Rights Act was the most important and provided the greatest societal and political change that this country has seen. But this is not going to fix the problem of the Supreme Court. And that's why I would ask my friends on the majority side, to step back and decide whether you want an issue or whether you want a law. I vote for a law. I yield back.
Gentleman yields back.
Mr. Chairman,
For what purpose is the gentlelady from seek recognition?
Strike the last word.
Gentlelady's recognized.
In the backdrop of the former chairman, Mr. Sensenbrenner, there is no doubt that Mr. Sensenbrenner has been a stalwart on these issues. And his words are certainly worthy of respect and consideration. I think it is important to take note, and I take note of the pronouncement of the gentleman from Louisiana, of his opposition. But I think it is worthy to acknowledge one singular point of this work. This bill does not create a problem, or it is not looking for a solution and searching for a problem. The voting infrastructure of America is broken. It's not damaged, it is broken. The Shelby case, with most lawyers' respect for the institution of the Supreme Court, was an unworthy pronouncement. Everyone, Republicans and Democrats, will admit the reauthorization that we did in the mid-2000s was done with 15,000 pages, and as Mr. Sensenbrenner has noted on other occasions, in an enormously bipartisan manner. 98 votes in the Senate and some 400-something in the House, and a Republican president enthusiastically signing the bill. We did not create this problem. But with the decision made by Shelby, the horrors of pre-1965 began to take root. I not only saw it in my district, it was all around the nation. The denial of legitimate voters the right to vote, voter intimidation, attacking people for being felons who are not felons, names being purged off a list, a voter ID law that, whatever your perspective on it, the initial one in Texas was found unconstitutional. It was written with the direct purpose of denying people the right to access an ability to vote. The structure of it was to go to Department of Public Safety offices, and 8 of our counties plus did not even have those offices, many of them lacking in predominantly Hispanic areas. We have a duty. And I want to read to you in the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges. Section 5 of Article 14 says the Congress shall have power to enforce by appropriate legislation the provisions of this article. 14th Amendment is cited in this bill. I hope ultimately that we will have a bipartisan approach as we make our way to the floor. I've worked with Mr. Sensenbrenner and many others, as the chairman has and as our very esteemed chair of the Constitution Subcommittee has made an effort to do so. But the problem exists. The duty of this committee and the Constitutional Subcommittee is to fix the problem within the context of the Constitution. There are many things that I see that we could engage in and add to. But we did the task of the Supreme Court, although I have indicated it was a wrong decision. It was a wrong decision as evidenced by Justice Ginsburg, who said, just because polio may have subsided, you don't stop the polio vaccination. We're stuck with the enormity of voter suppression, every single election, fear and intimidation. We must provide a guidepost, and we must adhere to the Constitution and stop denying citizens their rightful place and their rightful opportunity to vote. Our country is even more diverse than it was in 1965. That means that so many others find themselves being suppressed. So I'd ask my colleagues, let us work together to solve the problem, do the job, uphold the Constitution, and vote for the voting privileges of all Americans. I yield back.
Mr. Chairman,
For what purpose is the gentleman from Ohio seek recognition?
strike the last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. I won't take the full 5 minutes, but just wanted to make a couple of points. I'm a strong supporter and was the reauthorization of the Voting Rights Act. At the time this was last, and I want to associate myself with the remarks made by our colleague, Mr. Sensenbrenner. Mr. Sensenbrenner was chair of this committee at the time of the reauthorization many years ago. I was the chairman for 6 years of the Constitution Subcommittee, and my ranking member was none other than the current chair of this committee, Mr. Nadler, and we worked on this particular item very closely together, and were for the most part on the same side, and held a whole series of hearings with many witnesses, and it was bipartisan. And I still do support the reauthorization and would like to fix what the Supreme Court undid of the reauthorization last time, and there was a bipartisan attempt to do that, as Mr. Sensenbrenner mentioned. There are some areas where we just, Republicans and Democrats, both on this committee and not on this committee, just have some differences in the way we view it. One would be voter ID laws specifically. I think a lot of my colleagues on the other side of the aisle consider them for the most part to be discriminatory and a way to keep people from voting, and I'm not saying that that never happens, but in general, I'm supportive of voting rights law, voter ID laws. We actually have them in my state in Ohio, where you have to either show a driver's license or some other thing. We have to do it. It works very well in Ohio. And I think it's important that we make sure in our elections that the elections are secure, that a person votes one time in one place, and that that person is who he or she purports to be, and not somebody else. There have been abuses in various locations in this country where people have gotten on a bus or different ways and gone around and voted in different communities, even in different states, and that's the type of thing that this is supposed to stop, voter ID law. So in general, I'm supportive of voter ID laws, and in general, the particular legislation which we're considering today would discourage voter ID laws, and I think that they ought to be encouraged, and for that reason, I think it is unfortunate that we can't do this in a bipartisan manner, and I think Mr. Sensenbrenner is right. This is a messaging bill as much as anything else, which will pass this committee and probably will pass the House, but won't pass the Senate, and therefore will not become law. And that's a shame, because we really ought to reauthorize the Voting Rights Act. And did the gentleman want me to yield, or did you want to get your own time?
I have an amendment.
Okay, and did you want time, Mike?
I have an amendment, but I'll wait.
Okay, I'll yield back. Thank you very much.
Gentleman yields back for purposes of the gentleman from Tennessee seek recognition.
Yeah, I was hoping to strike the last word. I was hoping Mr. Sensenbrenner.
Strike the last word?
Yes, strike the last word.
Okay.
I was hoping that we could have Mr. Sensenbrenner let us know, and maybe somebody else on the Republican side knows, if his bill has a Senate sponsor, and maybe the Senate could pass that bill first if ours doesn't pass, and then we could take the Senate bill up. That would solve the problem.
Would the gentleman yield?
Yes.
Thank you. Let me just comment. The differences between H.R. 4 and what Mr. Sensenbrenner and I suppose Mr. Shabbat are advocating is essentially twofold. H.R. 4, the bill before us, prohibits, for the most part, voter ID laws on the grounds that they are used, that there's very little voter fraud, and that, or at least impersonation voter fraud, and that these voter ID laws in many states are used for the purpose of suppressing minority votes. Mr. Sensenbrenner and others would deny that to be the fact, obviously. The other difference is that we have a section on covered practices, that certain practices have been shown to be generally used for discriminatory purposes, and there's a provision in the bill that says that in jurisdictions with certain percentage of minority voters, those certain practices must be pre-cleared. Those are the two major differences between what we're proposing and the bill that Mr. Sensenbrenner and I suppose some of the other Republicans would support. And the gentleman says, well, we're just having a messaging bill, we're just having a bill that, will pass the House, not the Senate. I would point out we do have the Senate. The Senate is under Republican control. We feel strongly about the two provisions I mentioned. We pass the bill. If the Senate passes their version of a bill, maybe the Sensenbrenner bill, then you have conference and you'd have to decide what to do at that point. But to compromise at this point by getting rid of two provisions that we think important before you even start talking to the Senate does not make it a messaging bill. It would make it weaker for the negotiation. So our feeling is pass the bill the way we think it proper to pass, the way we think it proper to best protect voting rights. If the Senate doesn't agree, well, let's see if the Senate passes a bill at all. They can pass their, I'm not sure they would. But if they would, I hope they would, and they pass the bill similar to the one that Mr. Sensenbrenner is offering, then you negotiate at that point. But to pre-negotiate and compromise before you even talk to the Senate, which might not even take up your bill, seems to me a little counterproductive. So I don't think it's fair to say that this is a messaging bill. I do think it's fair to say that there's a significant partisan disagreement on these two provisions. You have a House controlled by one party, it's a Senate controlled by the other. We should pass the bill that we think, and hopefully some of our Republican colleagues will agree, is a very fair and a good bill that will help advance voting rights and help undo the disaster of the Shelby County decision. The Senate hopefully will pass a bill that they think will help the voting rights. And then, if the two bills don't match, then we can negotiate and perhaps negotiate over those two provisions. But there's no need to say at this point we're going to get rid of those two provisions before even talking to the Senate and disarm ourselves to start with. So that's my observation. It's why we're passing the bill this way. It's the proper bill. It's the bill we think will really help voting rights. If others disagree, when it comes to the Senate, we'll have the appropriate negotiations. I yield back. Who seeks?
Thank you.
Oh, I'm sorry. I yield back to. I thank the gentleman for yielding.
You're welcome, Mr. Chairman. I appreciate your putting your perspective forward so we know where we're coming from and the public can know also. I agree with you. It's not a messaging bill. Mr. Sensenbrenner, who I respect, said this won't pass the Supreme Court's test. Well, the first thing it's got to pass is the Senate's test, and the Senate can pass a bill, could pass Mr. Sensenbrenner's bill, and we go to conference. And I would submit if anybody needs to message on this bill, it'd be my Republican friends who support voting rights, and they could message by voting for this bill and then seeing what happens with the conference. But it's an opportunity for them to message because the messaging is important when people don't know where you are on an issue. When people know where you are on an issue, you don't have to message. You pass legislation. I yield. Yes.
I would quote in this context a former senator and former Secretary of State, John Kerry, who said with respect to some bill, I don't know what bill, I actually voted for it before I voted against it. And what he meant, I presume, was that he voted for the Senate version of the bill. The bill was changed in conference. He found the conference version of the bill unacceptable, and he voted against it. So I would point out to my Republican colleagues that if they approve the general thrust of the bill, they don't approve of a couple of provisions, they could vote for it now, and if and when it comes back from conference with the Senate, and if it is then unacceptable to them, then they can vote against it. But that's an option they have. I just wanted to point that out.
I yield back.
Mr. Chairman, I have an amendment at the desk.
And I reserve a point of order.
Wait. For what purpose does the gentleman seek recognition?
I have an amendment at the desk.
Gentlemen, the clerk will report the
I
amendment.
reserve a point of order.
Clerk will report the amendment. The gentleman reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 4, offered by Mr. Johnson of Louisiana. Add at the end the following. Section 10, Rule of Construction. For purpose of this act...
Reserve
Without
the
objection,
point of
the amendment
order.
is considered as read. The gentleman is recognized in support of the amendment.
Thank you, Mr. Chairman. I appreciate your quotation of former Senator Kerry. I'll raise the stakes and quote you John Adams. He said, facts are stubborn things, okay? We are in favor of voting rights, as has been explained with the history here and as everything we've said on the record. We don't have to prove it with a vote on this. The reason we can't vote is we don't have a partisan disagreement. We have a legal one. So this amendment today seeks to address what Professor Michael Morley and others have testified before the House Subcommittee on the Constitution. They've elaborated on exactly why Congress cannot constitutionally enact legislation such as H.R. 4 because it denies states and localities control over their voting rules, and there's no evidence they've been engaging in discriminatory treatment in voting based on race. Here's what Professor Morley said. Let me read it. He's an expert. He said, quote, "The Supreme Court's holding in City of Bernie held that a law enacted pursuant to Congress's enforcement authority under the 14th Amendment must be congruent and proportional to actual constitutional violations that can be established in an evidentiary record. Bernie's interpretation of Section 5 applies equally to Section 2 of the 15th Amendment and other voting rights amendments enforcement clauses. Congress has virtually plenary authority to regulate congressional and presidential elections. However, Congress's only authority to regulate elections at all levels of government, including state and local races, comes from Section 5 of the 14th Amendment and Section 2 of the 15th Amendment and other complementary voting rights enforcement provisions. The court has recognized," I'm still quoting the professor, "the court has recognized that an eligible voter who has validly cast a ballot has the fundamental right to have the ballot be given full weight and effect without being nullified or diluted by fraudulent votes, improperly cast votes, or votes cast by ineligible voters. States have a constitutionally significant interest in the enforcement of reasonable voting restrictions rather than always erring on the side of allowing people to vote despite doubts about their eligibility or the validity of their ballots. Election law must constantly strive to strike a balance between ensuring that all eligible voters are given an opportunity to cast their ballots while simultaneously preventing legitimately cast votes from being diluted, nullified, or effectively canceled out. When Congress exercises its enforcement clause authority, it's bound by the judiciary's interpretation of the Due Process Clause and Equal Protection Clause. In Bernie's key passage, the court held, quote, "There must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end," unquote. Purely prophylactic prohibitions that extend the constitutionally valid state laws may be appropriate when there is reason to believe that many of the laws affected by the congressional enactment have a significant likelihood of being unconstitutional. Legislation that goes beyond these restrictions cannot be deemed remedial, but rather constitutes an attempted redefinition of the underlying substantive right and exceeds Congress's enforcement authority. Last quote of the professor. "In considering whether a law satisfies Bernie's congruence and proportionality standard, the court scrutinizes a variety of factors. Most importantly, the court assesses whether a record of actual constitutional violations exists. It also considers whether the state conduct Congress targeted is intentional and hence potentially unconstitutional," unquote. Now look, Professor Morley and others testified, and they've said it clearly and repeatedly, H.R. 4 runs afoul of these constitutional principles because it doesn't base its remedies on actual discrimination in voting. We've been warned that if H.R. 4, as presented to us today, is ever enacted into law, it would follow a long list of unconstitutional federal statutes previously struck down by the Supreme Court, and for good reason. H.R. 4 even contains a requirement that certain election laws automatically be subject to preclearance. Found in Section 4A of H.R. 4, this practice-based preclearance would apply nationwide and would automatically cover election law changes such as modifying jurisdictional boundaries, voter qualification laws, including voter ID laws, and changes regarding bilingual ballot procedures, even when there is no evidence that any of these laws are discriminatory. The Supreme Court considers discriminatory treatment in voting a necessary justification for federal intervention in elections. Beyond that, I believe most people properly understand that the purpose of federal voting civil rights laws is to protect people from actual discriminatory treatment in voting, not to provide, again, a politicized DOJ with the means of shutting down reasonable state and local election laws, just to further some interest of one political party or the other. To rectify this, just one fundamental problem with the bill, I'm offering a very simple amendment. It's only a few lines, and it makes the following necessary clarification. It's a rule of construction, and it reads simply this. For purposes of this act and any amendment made by this act, a voting rights violation shall consist only of intentional discrimination that occurs on the basis of race, color, or membership in a language minority group. If the purpose of H.R. 4 is to constitutionally address actual racial discrimination in voting, it should say so clearly, and this amendment will make that so.
Will the gentleman yield?
Almost done.
Okay.
To my fun colleague from Louisiana. I got 4 seconds. The rejection of this amendment could only indicate that the purpose of H.R. 4 is to allow the federal government to control state and local election laws even when no actual discriminatory treatment based on race has occurred. Its common sense amendment reflects any fair-minded citizen's understanding of the purpose of the preclearance requirements, and I urge my colleagues to support the amendment, and I'm sorry I'm out of time because I'd like to yield.
Does the gentleman from Tennessee insist on his point of order?
No, sir. In the spirit of a great former member, a great mind, and a great bipartisan spirit, Caldwell Butler, I withdraw it.
The gentleman does not insist on his point of order. I'll recognize myself in opposition to the amendment first. I oppose this amendment. The Supreme Court's earlier decisions upholding the constitutionality of the Voting Rights Act understood Congress' constitutional authority to protect voting rights in broad terms. The Supreme Court has long viewed the Voting Rights Act as remedial, the purpose of the act being to remedy the grave and persistent constitutional harms caused by voter discrimination. In South Carolina versus Katzenbach, the first case to uphold the VRA, the court applied a rationality test, noting that Congress need only show that it had a legitimate end in enacting that law and that the means to achieve that are plainly adapted to that end, close quote. Congress amended Section 2 of the VRA back in 1982 to clarify that a plaintiff need not show both discriminatory purpose and effect to prevail in cases alleging vote dilution. In Shelby County, the court struck down the coverage formula and invited the Congress to enact a new formula based on current needs. Over the course of several hearings, this Congress, the Subcommittee on the Constitutional, Civil Rights, and Civil Liberties, has heard testimony from dozens of witnesses testifying to the need for Congress to address serious ongoing voter discrimination. It is well within Congress' authority to enact new coverage or bail-in provisions that subject certain specified practices to preclearance, which requires a jurisdiction to show that the practice does not have a discriminatory effect, or which permits a court to subject the jurisdiction to preclearance based on a showing of discriminatory effect. The gentleman from Louisiana quotes the Supreme Court decision in Birney versus City of Flores, I think it was, in Birney, in which a congruence and proportionality requirement were imposed on enforcement of the 14th Amendment. This bill, however, is based on the 15th Amendment. The Supreme Court has declined so far to impose a proportionality and congruence requirement such as found in Birney to the 15th Amendment. Now, some professors, some people argue, or hope, or both, that the Supreme Court will extend its ruling to say that there should be such a narrowing of the enforcement ability for the 15th Amendment. But what we have now is the Katzenbach rationality test, which is a very broad test and a very permissive test. So it is incorrect to argue that coverage of disparate impact is unconstitutional under the 15th Amendment. I therefore, and
Would the gentleman yield?
The necessity is clear, and yes, I'll yield.
That's a fair argument, but I would submit this response. In the city of Mobile v. Bolden, that's a 1980 case, the Supreme Court stated, quote, action by a state that is racially neutral on its face violates the 15th Amendment only if it's motivated by discriminatory purpose. Racially discriminatory motivation is a necessary ingredient of 15th Amendment violation, unquote. And in Reno v. Bossier Parish School Board, I live in Bossier Parish, Louisiana, the Supreme Court held that a plaintiff bringing a vote dilution claim under either the 14th or 15th Amendments must, quote, establish that the state or political subdivision acted with a discriminatory purpose, unquote. Congress's enforcement powers under Constitution appropriately extend only to preventing actual discrimination in voting. So the point is this: if this bill's preclearance formula isn't limited to apply to actual discrimination, it will be struck down by the Supreme Court. That's a certainty based upon the jurisprudence, and that's the reason we offered the amendment. And if it's not supported, this bill is going to be null and void, even if it were to pass, which it won't. I yield back.
Well, reclaiming my time in the City of Rome case, and I don't want this to get into a court argument about different citations, which we could go on all day with. But in the City of Rome case, the court did find that discriminatory impact was sufficient under the Voting Rights Act pursuant to the 15th Amendment. I'll yield back now, and who seeks recognition? Gentleman from Louisiana.
Well,
I didn't see anybody this side.
I was going to ask my colleague from Louisiana that basic question, that if your amendment gets on the bill, are you going to vote for the bill? Mike?
I would be much more inclined to vote for the bill, my friend, but I don't think you're going to pass my amendment, so it's a moot point.
Well, you never know. The second thing I would say is, and you talk about intentional discrimination, what your amendment addresses. I guess the question becomes, so let's say you're Texas or somebody and you pass voter ID that, school ID doesn't count, but a hunting license does count. Do we now have to go into the minds of the legislators if they all meet in the back room and decide that this is what they want to do because this is the effect of it? We need to go find intent, or does the fact that it hurts the ability for African Americans to go to the polls, is that enough of a reason for you? Or do you need to know that the person did it with the intent to discriminate?
Does the gentleman yield to the gentleman?
I yield.
So I was a constitutional law litigator for about 20 years, and you were a great attorney as well. And in constitutional cases, they're very fact-intensive, very fact-specific. And I believe that's why the Supreme Court, in good faith, ruled that there has to be a determination on the facts. So if you had a scenario like the hypothetical as you're presenting, if they did that to suppress minority voting, it should be invalid. But you have to make a determination of that. And we can't allow the DOJ at the federal level with people that work here to make pronouncements about decisions at the local and state level without digging into the facts. And that's all we're saying, because it's fairness. Ultimately, that's what drives all of us. We want fair elections. We believe in voting rights. But we have to have a court determination of that, because that is the safeguard. That's the guardrail.
Would the gentleman yield?
I yield back.
I'll yield.
Thank you. I would ask, just following up on the question from the gentleman from Louisiana, I'm caught between two gentlemen from Louisiana. I'll ask the other one. We've seen situations where, such as the gentleman alluded to, where a voter ID law is required and a college ID from the state university is not permitted, but a hunting license is. Do you think that, how would you, the obvious intent, I mean, it seems to me obvious, because you got a lot of minority people in the university, but perhaps a much smaller percentage having gun licenses, of the discriminatory effect, but you might not be able to prove discriminatory intent. How do you get into the minds of the legislature? The effect is obvious. I would think the intent is probably not obvious, but obvious, but not maybe legally obvious.
Well, can I respond?
Please.
So you might infer that, but we don't know the facts, and this is the point. I went to LSU, right? Back in my day, the student ID was the most easily fraud document. You can make a fake ID so easy from the LSU student ID, and people used to do it to get into games and stuff, right? That's different than a state-issued hunting license. In my state...
Would the gentleman yield for a second?
Wait, let me answer this. So I'm saying that it depends upon the facts. That's the point. We need a court of appropriate jurisdiction, someone who is an unbiased, objective reviewer of the facts, to look at that. Is a student ID in that particular state as valid and as reliable as a hunting license? Well, then maybe there was some ill intent, but we don't know that on the face of it, and you and I don't know that in Washington, and that's why we need a court of appropriate jurisdiction to look at it. That's the point.
I'll reclaim my time. I would just offer that some things are so blatantly discriminatory on its face that I don't think intent matters. And let's assume when you were at LSU, I know you all were making fake IDs and going to the...
I did not say I was.
It's inferred now. And now that LSU is undefeated, I'm sure you have a student ID again.
Amen, amen.
But part of it is, the question becomes the hunting license. African Americans are very underrepresented in a hunting license. So the question becomes, why do you include a hunting license, one, at all, two, a valid school ID from a public school? But the question is, why do you include the hunting ID? Why don't we just leave it at whatever the voter ID was? And I think that part of it is, if something is blatantly discriminatory, the question is really about, do we then have to go prove the intent of the author of the legislation, which will always be some, good-natured excuse. And I think that is the biggest concern I have with the amendment, and the fact that if I put your amendment on the bill, you wouldn't vote for the bill, or you would be, less likely to vote against it, is probably not enough. And with that, I yield back.
Gentleman yields back. Gentlelady from Georgia. For what purpose does the gentlelady seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady's recognized.
Thank you. With all due respect to my Republican colleagues, I'm from Georgia. And I was there and I witnessed the atrocious assault on the citizens of Georgia, particularly those of color, the assault on their ability to be able to vote in this last 2018 election. And so following the Shelby decision, my home state of Georgia, we saw a myriad of election problems that made it harder for people of color to vote. It undermined our faith in our electoral process and jeopardized our democracy. And since Shelby County, Georgians have repeatedly faced long lines at the polls. I've been there. I've been in those polls. Some have even fainted after waiting for hours in the heat. We even found a whole number of voting machines that were still wrapped and left in storage houses. More than 1 million Georgians have had their voter information purged from our voter files. That is a fact. And those who are recently naturalized, who earned their citizenship, they had to sue just to exercise their fundamental right to vote. And these threats to the rights of citizens in Georgia show just how much we need the Voting Rights Advancement Act. Hence the reason why we have Stacey Abrams, who's traveling all over the country now with her Fair Fight Act to ensure what happened to us in Georgia does not happen around the nation. So having experienced this myself in the state of Georgia, I am not a constitutional attorney or lawyer, but I know the facts and I know what has happened to us. And this is a great exercise in the right for everyone to be able to vote and to have their voices heard in our democracy. And I support 100% this legislation. I yield back the balance of my time.
Gentlelady yields back. Well, the gentleman from Tennessee, for what purpose does the gentleman seek recognition?
Strike the last word.
Gentleman is recognized.
I'd just like to suggest to Mr. Johnson, I was listening to Mr. Richmond's thoughts and your thoughts. People get fake IDs, student IDs. That's to drink. That's not to vote. And so if Louisiana really cares about its citizens, they should pass a law that says you can't use a student ID to buy liquor, because that's what they're for. I'll yield back the balance of my time. And we all know Louisiana, if you're old enough to walk, you're old enough to...
Gentleman yields back. For what purpose does the gentlelady from Arizona seek recognition?
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chair and members. Shelby County versus Holder struck down Section 4B, holding the formula is unconstitutional because the criteria used was outdated and thus violated principles of equal state sovereignty and federalism. The formula has not been updated since 1975. And Congress, is now trying to work to update it. Now, Arizona, the state that I'm from, was included, all political subdivisions were included in the original covered jurisdiction of the Voting Rights Act. And in 1975 reauthorization of the VRA, Arizona was also determined to remain covered under the act because ballots in Arizona were only provided in English at that time. However, in 2011, our Arizona Attorney General, Tom Horn, filed suit against the Department of Justice alleging that the Voting Rights Act formula was unconstitutional, and Arizona remained covered under the VRA until the holding in Shelby County invalidated Section 4 of the VRA. Arizona voters passed a number of years ago a ballot measure, and I think it was overwhelmingly to require voters to show IDs at the polls. And it was the will of the voters in Arizona that that be done. You had stated, Mr. Chairman, that this HR bill would disallow that. And that would go against what the voters and the majority of people in Arizona wanted. And I actually had a hearing, well, I didn't have a hearing. One of your Congress members had a hearing in Arizona. So we discussed this at large, and I can tell you that none of the testimony that was brought forward was from election officials in Arizona, unfortunately. But after the hearing, a number of election officials came up to me and said, we don't want to be back under federal authority, having to ask every single time we change anything in our election laws or do anything that we need permission from the federal government. So for those reasons and more, I'm going to oppose this bill. And I yield back my time.
Gentlelady yields back. The question occurs on the amendment. Those in favor? Did you want to say? My mistake. For what purpose does the gentlelady from Texas seek recognition?
Strike the last word.
Gentlelady is recognized.
The gentleman from Louisiana, the point that I wanted to make on the record is that we started out with Mr. Sensenbrenner saying, can we find a bipartisan pathway? In the instance of this amendment, it is seemingly gutting the bill and not acknowledging the disparities in voting practices that is prevalent not only throughout the South, but it is found in states across the nation. You just can't deny voting disparities and discrimination. We had a witness that was dealing with the Asian American community that doesn't have a long history, but had phenomenal growth in the United States and have experienced disparities by way of discriminatory practices that would diminish their right to vote. There are many jurisdictions that did not have multiple language ballots for citizens. So I'm confused as to how this is finding a solution to a problem. It seems to be creating a problem and then having a solution that doesn't answer the problem. And it makes it very, very difficult to support an amendment that seems to tear at the very fabric of the underlying bill, which is to enhance and promote voting opportunities for citizens of the United States. With that, Mr. Chairman, I certainly am opposing the amendment, looking forward to the gentleman working on a bipartisan initiative and hoping that he'll vote for the underlying bill that Ms. Sewell has offered and worked so hard on, and that our committee has provided a very strong basis for a series of hearings and thousands of pages of testimony. With that, I yield back.
Gentlelady yields back. The question occurs on the amendment. Those in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the nays have it. The amendment is not agreed to. Are there any further amendments to the amendment in the nature?
Recorded vote. Sorry.
The gentleman requests a recorded vote. The clerk will call the roll.
Mr. Nadler? No. Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson of Georgia? Mr. Deutsch? Ms. Bass? Ms. Bass votes no. Mr. Richmond? Mr. Richmond votes no. Mr. Jeffries? Mr. Cicilline? Mr. Swalwell? Mr. Liu? Mr. Raskin? Mr. Raskin votes no. Ms. Jayapal? Ms. Demings? Mr. Correa? Mr. Correa votes no. Ms. Scanlon? Ms. Scanlon votes no. Ms. Garcia? Ms. Garcia votes no. Mr. Neguse? Ms. McBath? Ms. McBath votes no. Mr. Stanton? Mr. Stanton votes no. Ms. Dean? Ms. Dean votes no. Ms. Mucarsel-Powell? Ms. Mucarsel-Powell votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Collins? Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Jordan? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes aye. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes aye. Mr. Biggs? Mr. McClintock? Ms. Lesko? Ms. Lesko votes aye. Mr. Reschenthaler? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes yes.
Gentleman from Rhode Island, Mrs. Cicilline.
Mr. Cicilline votes no.
Mr. Deutsch.
Mr. Deutsch votes no.
Ms. Jayapal.
Ms. Jayapal votes no.
Are there any other members of the committee who wish to vote who haven't voted yet? The clerk will report.
Mr. Chairman, there are 6 ayes and 18 noes.
The amendment is not agreed to. Are there any further amendments to the amendment of in the nature of a substitute? The question then occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final passage of the bill. All those in favor of the amendment in the nature of a substitute respond by saying aye. Aye. Opposed, no. No. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill, H.R. 4, as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no.
No.
And the ayes have it, and the bill is ordered reported favorably. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Aye. Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson of Georgia? Mr. Deutsch? Aye. Mr. Deutsch votes aye. Ms. Bass? Ms. Bass votes aye. Mr. Richmond? Mr. Jeffries? Mr. Cicilline? Aye. Mr. Cicilline votes aye. Mr. Swalwell? Mr. Liu? Mr. Raskin? Aye. Mr. Raskin votes aye. Ms. Jayapal? Ms. Jayapal votes aye. Ms. Demings? Mr. Correa? Aye. Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Ms. McBath? Ms. McBath votes aye. Mr. Stanton? Aye. Mr. Stanton votes aye. Ms. Dean? Ms. Dean votes aye. Ms. Mucarsel-Powell? Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Collins? Mr. Sensenbrenner? Mr. Shabbat? Mr. Gomert? Mr. Jordan? Mr. Buck? No. Mr. Buck votes no. Mr. Ratcliffe? Ms. Roby? Ms. Roby votes no. Mr. Gates? Mr. Johnson of Louisiana? Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. McClintock? Ms. Lesko? Ms. Lesko votes no. Mr. Reschenthaler? Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Stubbe? Mr. Stubbe votes no.
Are there any members of the committee who have not voted who wish to vote?
Ms. Mucarsel-Powell votes yes.
We have a number of members, I'm told, on the way, so we will hold the vote open for a moment or two.
Mr. Richmond votes yes.
Mr. Richmond votes yes. We have a number of members on the way, so we'll hold the vote open for a moment or two.
How am I recorded?
Ms. Jackson Lee, you are recorded as aye.
Thank you.
We have a number of members who are a couple of minutes away, and I would ask unanimous consent to proceed with the next bill, but to hold the rolls open. No? Unanimous consent, you can do it. I would ask unanimous consent to hold the vote open for a couple of minutes while we proceed to the next bill for anybody who may arrive, but we're told a few people. Otherwise, we can sit here for 3 minutes or so. All right, I'm told we. All right, we can't do that. We'll wait a minute. I tried. Otherwise, we'd do it every time, and nobody would come to our meetings. We'll give it one more minute, and then that'll be that. Gentleman from Colorado?
Mr. Neguse votes yes.
Okay. The clerk will report.
Mr. Chairman, there are 19 ayes and 6 noes.
The ayes have it. The bill is amended, is ordered reported favorably to the House. Members will have 2 days to submit views. The bill will be reported as a single amendment in the nature of a substitute incorporating, well, there were no adopted amendments, and without objection, staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 565, the Advancing Mutual Interest in Growing Our Success Act, or the AMIGOS Act, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 565, to include Portugal in the list of foreign states whose nationals are eligible for admission into the United States as E1 and E2 non-immigrants if United States nationals are treated
Without
similarly.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 565, the Advancing Mutual Interest in Growing Our Success, or AMIGOS Act, is bipartisan legislation that would provide Portuguese nationals the ability to apply for E1 and E2 non-immigrant visas if the government of Portugal provides a similar visa program to United States nationals. The E1 Treaty Trader Program provides temporary visas to individuals and employees of businesses to come to the United States to engage in substantial international trade. The E2 Treaty Investor Program provides similar visas to those who make a substantial investment in a U.S. enterprise. The E1 and E2 visa programs boost our economy by increasing trade and direct investment in the United States. They also improve foreign relations with our allies. More than 80 countries already participate in these programs, including nearly all our foreign allies and trading partners. Yet Portugal, one of our closest and oldest allies, is not on the list. Portugal has been a friend of the United States for more than 220 years, with ties dating back to 1791. Today, the United States is Portugal's largest trading partner outside the European Union, with bilateral trade in goods and services reaching $8 billion in 2018. H.R. 565 is a common-sense bill that would provide a means for Portuguese nationals to come to the United States to create jobs and facilitate trade and investment, while allowing U.S. nationals to do the same in Portugal. This bill is an uncontroversial way to help both our countries spur economic growth and job creation while deepening our ties to one of our oldest allies. I congratulate the gentleman from Rhode Island, Mr. Cicilline, co-chair of the Portuguese-American Caucus, as well as Mr. Nunes and Mr. Costa of California for championing this bill. It is not easy these days to find common ground in immigration issues, but as a result of their efforts, our country will be more prosperous, as will Portugal. I thank them for introducing this bipartisan legislation, and I urge my colleagues to support the bill. I now recognize the ranking member, the ranking member of the Judiciary Committee, the gentleman from Georgia, Mr. Collins, will have his opening statement placed in the record. I now recognize the chair of the Subcommittee on Immigration and Citizenship.
I think ranking member.
Oh, I'm sorry. I thought he was next. Yes, yeah, okay. I now recognize the ranking member of the Immigration Subcommittee, the gentleman from Colorado, Mr. Buck, for his opening statement.
Thank you, Mr. Chairman. I appreciate the opportunity to comment on H.R. 565, the Advancing Mutual Interest in Growing Our Success Act. This bill adds Portugal to the list of countries whose nationals the U.S. recognizes as being eligible for E1 and E2 visas. E1 visas are non-immigrant visas available for treaty traders, and E2 visas are available for treaty investors. Pursuant to the Immigration and Nationality Act, these visas are available to aliens who are, quote, entitled to enter the United States under and in pursuance of the provisions of a treaty of commerce and navigation between the United States and the foreign state of which a national and their spouse and children solely to either carry on substantial trade, including trade in services or trade in technology, principally between the United States and the foreign state of which he is a national, or to develop and direct the operations of an enterprise in which he has invested a substantial amount of capital. Alien employees of treaty traders and treaty investors may receive visas if they are coming to the U.S. to engage in duties of an executive or supervisory character, or if employed in a lesser capacity if they have special qualifications to make the services to be rendered essential to the efficient operation of the enterprise. There are no numerical caps on E1 or E2 visas. Aliens may be admitted initially for a period of 2 years and can apply for extension in 2-year increments. One thing that is important to understand is that Portugal will be extending similar visa opportunities for U.S. citizens. In a world increasingly interconnected by trade, the e-visa program is important to help facilitate international trade and for promoting economic prosperity for the U.S. and U.S.-based businesses. The U.S. has entered into treaties of commerce for some time, at least since 1815, when we first entered into a convention to regulate commerce with the United Kingdom. Currently, nationals from 84 countries are eligible for E1 and/or E2 status. During fiscal year 2017, the U.S. issued a total of nearly 48,000 E1 and E2 visas. In the past, countries became eligible for the E1 and E2 programs through treaties signed with the U.S. Excuse me. However, in 2003, the Judiciary Committee reached an understanding with the U.S. Trade Representative that no immigration provisions were to be included in future trade agreements. Thus, legislation is now required to add countries. H.R. 565 makes Portuguese nationals eligible for E1 and E2 visas. I urge my colleagues to support the bill, and I yield back.
The gentleman yields back. For what purpose does the gentleman? Oh, I'm sorry. I now recognize the gentlelady from California, the chairperson of the Subcommittee on Immigration, for her opening statement.
Thank you, Mr. Chairman. I'd ask unanimous consent that my full statement be made part of the record.
Without objection.
I will not reiterate the comments made about the program itself, but it's just worth noting that unlike other European Union countries, the United States and Portugal did not have a bilateral trade and investment treaty in place before Portugal joined the EU, and that left them out. So even though they are one of our longest-standing allies and closest economic partners, Portugal is one of only 5 EU countries whose citizens are not eligible for e-visas. And this bill, which I am happy to co-sponsor, will help change that. There are more than 130 U.S. companies operating in Portugal today and more than 100 Portuguese companies in the United States. That is good for both nations. I would note that the e-visa programs have played a very important role in U.S. foreign policy for decades, as well as our economy. As you'll recall, last year we added New Zealand and Israel to the Treaty Trader program. That was done by unanimous consent in the Senate in the case of New Zealand, and by suspension voice vote in the House, and Israel as well. So just a further note, the GAO recently concluded an audit of the e-visa program, and I'm pleased to report that they found virtually no problems whatsoever. They found fraud in less than 1/100% in e-visa cases. So there's a good track record here. This is good for both countries. I'm happy to support it. And by the way, we did reach out to the Department of State, and they have no objections to this bill. So with that, I would yield back, Mr. Chairman, thanking Mr. Cicilline for his leadership in introducing the bill.
The gentlelady yields back. For what purpose does the gentleman from Rhode Island, the distinguished chairman of one of the subcommittees of this committee and the distinguished sponsor of the bill, seek recognition?
Mr. Chairman, I seek recognition to speak in support of the bill.
Gentleman is recognized.
Thank you, Mr. Chairman, for holding this markup on H.R. 565, the Advancing Mutual Interest in Growing Our Success Act, or the AMIGOS Act. And thank you for your very kind words in your opening statement, and thank you to the chair of the Immigration Subcommittee, Congresswoman Lofgren, for your support and kind words. As was mentioned, this is a bipartisan bill that I introduced with Mr. Costa and Mr. Nunes to encourage greater investment in trade between the United States and Portugal. H.R. 565 makes Portuguese nationals eligible for E1 and E2 non-immigrant visas if the government of Portugal provides similar non-immigrant status to U.S. nationals. Access to these investor visas will allow Portuguese investors to support projects in the United States, benefiting our economy as well as that of Portugal. As the first neutral country to recognize the United States after the Revolutionary War, Portugal is one of our closest economic allies and strongest partners. Today, the United States maintains that long-standing relationship as the 5th largest export market for Portugal and its largest trading partner outside the European Union. I'm proud to represent the 1st District of Rhode Island, which has the highest percentage of Portuguese Americans of any congressional district in the country. And so I've seen firsthand the contributions to the arts, to culture, to business, and to public service for many decades. From 2010 to 2015, we saw a 30% increase in trade between the United States and Portugal. 2015 also marked the year that the United States became Portugal's largest trading partner outside the European Union, with bilateral trade reaching $4.2 billion. Bilateral trade in goods and services between the United States and Portugal has continued to grow, with a 9% increase to $8 billion in 2018 when compared to just a year earlier. There are currently over 130 American companies operating in Portugal in a wide range of economic sectors, including pharmaceutical, chemical, technology, banking, and healthcare. In 2018, the United States' direct investment position in Portugal was $2.8 billion, an increase of 37% from 2017. The direct investment position from Portugal to the United States, however, experienced a 3.5% decrease to $1 billion from 2017 to 2018. While the majority of the countries within the European Union had pre-existing bilateral investor treaties with the United States before joining the EU, Portugal did not, and is one of only 5 EU countries whose citizens are not currently eligible for E1 or E2 visas. In the absence of a bilateral treaty, which Portugal cannot enter due to the rules of the European Union, Congress has the power to authorize E1 and E2 visa benefits to other countries. And we have exercised our authority to do just that with Israel in 2012 and New Zealand just last year, and I'm pleased to lead the effort to do the same for Portugal. Foreign direct investment plays a significant role in the U.S. economy. One of the most important factors in encouraging investments in the United States is the availability of business-related visas like non-immigrant E1 and E2 visas. Allowing Portuguese nationals to be eligible for E1 and E2 non-immigrant visas will increase direct investment by Portugal in the United States. Without the availability of E1 and E2 visas, difficulties in obtaining timely visas can act as a barrier for growth between both countries. Allowing Portuguese citizens access to conduct substantial trade between the United States and Portugal, or invest a substantial amount of capital in the United States to qualify for non-immigrant E1 and E2 visas will help strengthen U.S.-Portugal ties and promote an increase in Portugal's investment in the United States. Extending visas to Portugal not only gives Portuguese businesses an opportunity to invest in the United States, but it's a mutually beneficial relationship that promotes jobs in both countries and growth in the United States business and economics. I'm proud to lead this effort and to support our ally and friend Portugal, and I thank you again, Chairman Nadler, for holding this important markup today, and I encourage all of my colleagues to support H.R. 565, and I yield back.
The gentleman yields back. The reporting quorum being present, the question is on the motion to report the bill H.R. 565 favorably to the House. Those in favor say aye. Aye. Opposed, no. The ayes have it, and the bill is ordered reported favorably to the House. Members will have 2 days to submit views. This concludes our business for today. Thanks to all our members for attending. Without objection, the markup is adjourned.